Hello everyone, my name is Mohammed-Khan and I'm an attorney at law. These are some ideas on the legal and social aspects of same-sex unions in Trinidad in June 2026. What are same-sex relations? Difficulties for same-sex couples. Current law in Trinidad. Acts and programs pertaining to same-sex marriages. Law for same-sex unions in other countries. Actionable solutions. What are same-sex relations? This is a union of two male or two female parties being in a home together as a couple and living as a family. In Trinidad, cohabiting same-sex couples do not have legal protection as opposite-sex couples. Difficulties for same-sex couples. There are difficulties if there is no will. The laws of succession for letters of administration, as shown in the Administration of Estates Act, Chapter 901, does not include a same-sex partner. Automatic rights for numerous types of insurance and annuities are also limited. Same-sex partner is not considered a next of kin in medical emergencies. In the Distribution of Estates Act 2000, the definition of cohabitant applies to heterosexual couples only. There is no provision for distribution of estates for same-sex partners. There are limitations on fostering children, guardianship, and adoption. There are tax implications for same-sex couples who do not have the same benefit as heterosexual couples in filing their tax returns. There are problems faced from property and tenancy rights. There are problems in employment benefits for same-sex couples, like medical benefits and attending staff events. Some solutions are a will. It is essential in giving property to a same-sex partner. The partner must be specifically named as a beneficiary on some insurance policies, and the solution is often to have a power of attorney. Current law in Trinidad. Jason Jones versus the Attorney General of Trinidad and Tobago 2018. This was a landmark case, 14-page judgment, which stated that same-sex couples, because they consent, the laws of Section 13 and 16 of the Sexual Offences Act 1986, Section 13 is against buggery and Section 16 is against serious indecency, do not apply. The questions of the rights under the Constitution versus the law of buggery, this was the issue. This was a triumph for the same-sex unions. However, it was short-lived as the Attorney General's office appealed the matter. Attorney General versus Jason Jones, 2025. The decision on appeal was a long 198-page document which highlighted the sections of the Constitution, the laws in question, and saving clauses. Law clauses in Trinidad and Tobago's Constitution which protect laws that existed prior to independence from being invalidated by the courts on human rights grounds. The lower court's decision was overturned, recriminalizing laws but at the pre-1986 levels of penalty. Jason Jones took the matter to the Judicial Committee Privy Council, and the matter comes up in July 2026. While the law is evolving in Trinidad, the persons in the same-sex union suffer and continue to suffer difficulties and discrimination in their daily lives. Acts and programs pertaining to same-sex marriages. In the Netherlands in 2001, there was an act on the opening of marriages to legalize same-sex marriage, grant same-sex couples full marriage, formal registered partnership, which they had since 1998. Same-sex couples married same rights and were given same rights and responsibilities as heterosexual couples. Tax benefits, adoption laws protects against discrimination, hate speech, discrimination in employment, healthcare, housing, and public services. This law extends to European Netherlands, Caribbean Netherlands, like Bonaire, St. Eustatius, and Saba, and Aruba and Curacao. In England, it provides civil partnerships and same-sex marriages. The Civil Partnership Act of 2004 legalized civil partnerships between same-sex couples, and the Marriage Same-Sex Couples Act of 2013 legalized same-sex marriages. Earlier cases which protected same-sex couples in tenancy and property rights are Guidon versus Gordon Mendoza, and in adoption, Re P. Children, 2008, UK House of Lords. Laws for same-sex unions in other countries. In the United States of America, Obergefell versus Hodges, Director, Ohio Department of Health. This was a landmark case in 2015 that legalized same-sex marriage. Extensive jurisprudence and reasoning in favor. Judges were Anthony Kennedy, Ruth Bader Ginsburg, Stephen Breyer, Sonia Sotomayor, and Elaine Kahn. Dissenting judges were John Roberts, Antonin Scalia, and Clarence Thomas. The case concluded that a fundamental right to marry is guaranteed to same-sex couples by both the Due Process Clause and the Equal Protection Clause of the 14th Amendment of the U.S. Constitution. All 50 states, the District of Columbia, and insular areas of the U.S. sovereignty to perform and recognize marriages of same-sex couples on same terms and conditions as marriage of opposite-sex couples with equal rights and responsibilities. The Due Process Clause. The right to marry is a fundamental liberty protected by the Due Process Clause. Individual autonomy, protection of intimate association, safeguarding of families and children and marriages, foundational role in social order. The Equal Protection Clause. Denying same-sex couples the right to marry treats them as second-class citizens and causes them material and dignitary harm and excludes them from significant social institutions. The intersection of the clauses. The due process and equal protection deeply connected. In this case, denial of fundamental rights to marry inherently resulted in inequity and states' unequal treatment burdened plaintiffs' fundamental identities. The personal right to dignity. Freedom to marry is deeply tied to personal dignity and individual identity. Evolving understanding. Rejecting the argument that marriage must be defined strictly by historical traditional constitution protects fundamental liberty as societal understanding of those liberties evolves. He wrote that new insights reveal how legal structures conflict with constitutional protections. Respect of Marriage Act 2022, this recognizes marriage validity performed in other states. Laws for same-sex unions in other countries. We're looking at India now. Homosexual sex between consulting adults is no longer a criminal offense in India. Since this case of Navtej Singh Johar versus the Union of India, that was in 2018, it unanimously struck down Section 377 of India Penal Code in colonial law that criminalized carnal intercourse against the order of nature. It looked at the constitutional rights, Section 377, which violated fundamental rights, including the right to life, dignity, equality, and privacy order. Consensual relations were legally allowed. Justice Deepak Mishra held in that case that criminalizing carnal intercourse to be irrational, arbitrary, and manifestly unconstitutional. He ruled that LGBTQ people in India are entitled to all constitutional rights, including the liberty protected by the Constitution of India. It held that the choice of whom to partner, the ability to find fulfillment in sexual intimacy, and the right not to be subjected to discriminatory behavior are intrinsic to the constitutional potential of sexual orientation. The same-sex couples, however, do not have full marriage equality in India. according to that case of Suprio versus the Union of India in 2023. In Trinidad, the matter is before the Privy Council, and as the law is still evolving, the discriminatory practices against same-sex couples continue. Actionable solutions. Same-sex couples should ensure that they have wills, powers of attorney which allow access to banks and to give directions for medical care, and be named as beneficiary on insurance policies. Many other areas of life are still unable to be catered for without a change in the law, and Trinidad awaits. The matter comes up in the Privy Council in July 2026.